Yes, Mr. Brealey.
So on the first ground, I said there were three things I'd do. I'd recap on the zero myth argument. I would show how the same argument was run and rejected by the CJO and MasterCard. Now I turn to the third to explain why the Court of Appeal was right to reject the zero myth arguments. This is the third point I want to make. I can do this quite quickly. If I can go to the Court of Appeal, which is at Core Volume 2. It starts at MS 5199. In my submission, the Court of Appeal was correct for two reasons. First, the Court of Appeal was correct to conclude that the CJEU's reasoning was binding. So it was correct to say that the reasoning was binding. But second, in any event, the Court of Appeal was correct to agree with the CJEU's reasoning. And indeed, it came up with things of its own, which you'll see in a moment. It came up with a counterfactual of its own. On the binding aspect, we've seen many of these paragraphs, so I'll just really go through them quite quickly. If we go to, so we take the Commission's infringement decision first, go to MS 5237. This is paragraph 133. Where the Court of Appeal says the Commission was dealing with the same factual situation. Mr. Turner referred to that this morning, but we respectively agree with that. It then turned to the General Court, and the relevant paragraphs of the Court of Appeal, MS 5238, paragraph 141, you see there exactly the same points. First line. Paragraph 142, 1, 2, 3, 4 lines up, not materially different. Paragraph 144, second line, same arguments. And paragraph 146, we've seen before, last sentence, this reasoning seems to be a conclusion of law. We respectively agree with what the Court of Appeal was saying there. It goes on to look at the CJEU, two paragraphs that are relevant there. Paragraph 156 at MS 5241. 156 at 5241. The proper analysis of the CJA decision is it's endorsing as a matter of law. And then going on to MS 5245 at essentially the last sentence, the Court of Appeal is saying the correct counterfactual. So this is paragraph 172, MS 5245. We agree with the last sentence. The Court of Appeal saying the correct counterfactual envisaged no default myth and a prohibition on ex post pricing.
In 156, first sentence, do you agree that there seems to be an ellipsis? The CJU, rather than endorsing the counterfactual adopted by the General Court, was perhaps it means endorse the analysis of the counterfactual.
I think so, yes. Right. The analysis relating to the counterfactual, yes. Yeah. So materially indistinguishable, quite clearly we say. And then why is that binding? Well, the answer is at section 60. The Court of Appeal refers to this at paragraph 130, MS 5236.
Sorry, reference again, please.
Yes, beg your pardon. 5236, paragraph 130. We don't need to go to it, but it's in Authority Bundle 1, tab 1, section 60. But the Court of Appeal sets it out there. And the essential point is that it is a corresponding question. Section 60 requires consistency with corresponding questions. And we submit, maybe we should go to it. So tab 1. Section 60 in brackets 1 refers to corresponding questions, and section 60 in brackets 2, at any time when the court determines a question under this part, it must, with a view to securing that there is no inconsistency between the principles laid down by the treaty and the European Court and any relevant decision of that court in determining any corresponding question. And we would submit that, given the facts and the analysis, it is a corresponding question, and the Court of Appeal was quite right to try to ensure consistency with how this has been dealt with. Otherwise, you end up, like we did below, with 3 inconsistent judgments. So that is essentially why we say the Court of Appeal was correct to say it was binding. We have also, in our written case, that the Court of Appeal actually agreed with the reasoning. We refer to this at paragraph 125 of our written case. And there are 2 points to emphasise by way of conclusion on ground 1 in this respect. The first point, whether there is a zero myth at all. The zero myth argument is obviously not based on any actual collective agreement not to charge an extra fee. We have 3 scheme rules: the settlement of the purchase price, the 2 scheme rules. And if I could go to paragraph 126 of the judgment, the Court of Appeal. Read there, we endorse what the Court of Appeal says there. That is the proper approach to the counterfactual. And the schemes do, we say, ignore these fundamental propositions. You can't look at the myth of 8 pence by reference to a myth of 1 pence, 0, negative, because you're still looking at a counterfactual with a myth. And that is the whole purpose of a counterfactual, is to look at the state of competition without the restrictive agreement in hand. That is to say, with no myth. And that is why the correct description of the counterfactual is a no myth counterfactual rather than a zero myth counterfactual. It's a very simple point. The second point is that even if you consider that the SAP is actually a zero myth in a hypothetical counterfactual, the zero myth is less restrictive of competition than a myth which allows for an extra charge. This is because the hypothetical collective agreement to charge nothing is simply reflective of what the market will bear. It is a recognition that market forces would result in no charge being paid. That's why I referred to the evidence of Mr. Ashworth and his reference to commercial reality. By contrast, a collective agreement to surcharge is not reflective of market forces. It distorts market forces by giving certainty to the acquirers and depriving merchants of their negotiating power. Second point here is that the SAP is less restrictive of competition. Again, that is the whole purpose of a counterfactual. My Lords will be pleased to know that that is the end of ground one. Unless there's any questions, I was going to actually go to the third ground, fair share. What I'll do is fair share, and then follow that with broad acts, and then tomorrow I will evidence. The third issue arises from Visa's ground of appeal. MasterCard does not appeal this issue. And could I just go to paragraph 94 of the Court of Appeal's judgment? That is at MS 5228. MasterCard has not appealed. We don't believe that MasterCard is neutral on this, because if one looks at paragraph 94, the last sentence, so paragraph 94 is setting out the merchant's argument. Mr. Justice Popperwell held that a fair share for merchants must not leave them worse off. The second condition will not be satisfied if merchants are worse off. That analysis was not the subject of any respondent's notice from MasterCard during the course of argument. Mr. Hoskins said it was agreed. So I just put that out there because it appeared to be yesterday Mr. Hoskins was saying it's all very neutral. We understood that MasterCard actually agreed with the merchant's interpretation and said so to the Court of Appeal. Visa's case depends on an interpretation of the CJEU ruling. And to put this in context, could we just go to our written case, please, which is Core Bond 1. Tab 19 at MS 5062. This is where we start the fair share. The second condition of Article 1013 provides that consumers must obtain a fair share of any benefits or efficiencies that result from the restrictive agreement. The question on appeal is whether the relevant consumer for the second condition is both retailers and cardholders, as Visa contends, or just retailers, as the Court of Appeal found. We make the point that only Visa advances the ground. I want to emphasise not only the fact that Visa's argument has been described as absurd by the Commission, not involving a sensible reading of the case law. Court of Appeal will come to that. But what I do want to emphasise is the last sentence of paragraph 175, is that Visa's arguments involve disregarding the way that the second condition has been applied for many years. And we did not get a sense of that when Ms. Rose gave the submissions on that, and that's what I want to address now. The starting point is regulation, is the modernisation regulation, Regulation 1/002. And that's Authorities 1, tab 16. That's MS 447. This is Regulation 1/2003, the modernisation regulation, and the relevant recitals are recitals 1 to 4. Or just quickly skims there, then I'll just give the sense of the relevance.
I see. So this replaced the old Regulation 17 and set up a system which gave a much greater role to the national authorities.
It did. So, as my Lord, until that time, only the Commission could grant the exemption. There was a system of notification. The Commission had the practice, and this recognised that that was not going to work in a large community, and therefore courts now have the power to grant an exemption. And just for that, we see that in Article 6, on page 455, national courts now have the power to apply Article 1 and 80 to in their entirety. So they have the power to apply Article 101. So that's the starting point. Article 45 of the regulation provides that the regulation would come into force from 1st of May 2004. So 2004 is quite an important date for the modernisation of European law. And that essentially leads me to, we can put that away, but it leads me to the guidelines, 1013 guidelines, which are important, at Authorities Volume 3, tab 30. We've got the modernisation regulation. And these guidelines are essentially given, they're published at the same time, 2004, and they are there to assist national courts in how they are going to exercise their newfound powers. And we see this from recital 4. So it is telling the courts what is the previous practice of the Commission, both in the light of its experience and the case law. So on the fair share requirement, and again, we've tried to set this out in our written submissions as much as we can, but there's no substitute for actually going to the documents. Could we go to MS 1629, which is the fair share condition? So, just going back, if you want to 1628, just to put where we are, this is under second condition of Article 81.3, fair share for consumers. So that's where paragraphs 85 and 86 are important. The concept of fair share implies that the pass-on of benefits must at least compensate consumers for any actual or likely negative impact caused to them by the restriction of competition. And I ask the court to emphasise, to underline compensate, because we'll come back to that in a moment. In line with the overall objective of Article 81 to prevent anti-competitive agreements, the net effect of the agreement must at least be neutral from the point of view of those consumers directly or likely affected by the agreement. We will come back to footnote 80 in a moment. If such consumers are worse off following the agreement, the second condition of Article 81.3 is not fulfilled. The positive effects of an agreement must be balanced against and compensate for its negative effects on consumers. When that is the case, consumers are not harmed by the agreement.
Before we discuss that, is it perhaps important for us to look at 84, paragraph 84?
That says who the consumers are, yes.
Yes, because that seems to be, that's part of the argument here, I think, isn't it? Whether the consumers we're talking about are the
Merchants or the cardholders.
the merchants or also the cardholders.
Yeah, and merchants and cardholders can be consumers. There's no
Yeah, but in
doubt
different
about
markets.
that. But the question is, for the second condition, which consumer are you going to talk about? The consumer on what market? That is the question of law. On what market? Because cardholders are consumers on the issuing market, merchants are consumers on the acquiring market. And merchants, and we will see this, so I'm going to get the principles first and then see how it was dealt with in the Commission decision. But it is consumers on the market affected by the agreement, and that is accepted to be the acquiring market in this case. So consumers on the acquiring market, the affected market, must be compensated. 86, it is not required, this is paragraph 86, it's not required that consumers receive a share of each and every efficiency gain. It suffices that sufficient benefits are passed on to compensate for the negative effects of the restrictive agreement. In that case, consumers obtain a fair share of the overall benefit. If a restrictive agreement is likely to lead to higher prices, consumers must be, and I emphasize this, fully compensated through increased quality or other benefits. If not, the second condition of Article 81.3 is not fulfilled.
I mean, if you look at 84, the users of, or the products covered by the agreement aren't the credit cards. The products, it's more a case to do with services and products, but presumably the product, if you like, is the service being provided by the acquirer banks to the merchants. That's what the MSC is payable for.
There is no doubt in this case that there are two consumers, merchants and cardholders, and two markets, acquiring market and issuing market. I mean, that is accepted, that's accepted facts amongst all the parties.
Yes, but the market in which the restriction exists is the acquirer market, is the market for services provided by acquirer banks to merchants.
Yes, merchants pay the charge, therefore are harmed by the restrictive agreement because they are paying a fixed price. And so paragraphs 85 and 86 under the second condition are saying, are the consumers on the affected market where the distortion of competition happens, are they compensated in full? Are those consumers no worse off? It is, as we'll see, market specific. So, as we've set out in our written case, the footnotes to paragraphs 85 and 86 are important. Mr. Justice Phillips forgot about one of them and the Court of Appeal rectified it. So it is important to look at footnote 80 to begin with. And we see that at the last page of the guidelines. So again, just to recap, the Commission has said in 85, In line with the overall objective of Article 81 to prevent anti-competitive agreements, the net effect of the agreement must at least be neutral from the point of view of those consumers directly or likely affected by the agreement. Footnote 80 refers to the Constant and Grundig case. That is at, we'll leave the guidelines open, but that is at volume 2, tab 17. So this is a seminal case of Constant and Grundig. It's MS 472, tab 17. And it's at MS 532, MS 532. So this is the paragraph referred to by the Commission where it says consumers affected must be compensated. And it's the paragraph that begins the existence of an improvement, which is the relevant paragraph. The existence of an improvement in production or distribution of the products in question, which is required for the grant of it, should be judged in the light of the spirit of Article 101. It makes a first point: this improvement should not be identified with all the advantages which the partners gain from the agreement in their production or distribution activity, advantages which are generally indisputable and which will show the agreement in all its elements is thus understood. Such a subjective measure which makes the content of the notion of improvement depend on the particularities of the contractual relations in question would not conform to the aim. That is why the profits to the banks would never receive an exemption under Article 101.3. We see this in the guidelines. But it's the next point which is important. Further, the very fact that the treaty provides that the limitation of competition should be indispensable to the improvement in question clearly indicates the importance which the latter should have. The improvement should in particular present noticeable objective advantages such as to compensate for the inconveniences, i.e. the harm, resulting therefrom on the level of competition. So that is the Commission taking this paragraph of Constant and Grundig, and we shall see when we come to the CJU's judgment in MasterCard, the court referring to this case. That's why I say it is very important to remember that from 1966, the court has said the objective advantages must compensate for the harm. So I emphasize the word compensate. So that is the Constant and Grundig case.
And is that talking specifically about the fair share criterion, or more generally?
I think that's generally, because it's talking about the improvement.
Yes.
Which would smack of Article with the first condition. But indispensable obviously relates to the fourth condition. So it's relating generally. But clearly the Commission is taking this as it starts with looking at the spirit of Article 101. The Commission is looking at this. It must be a character to compensate. And we shall see at footnote 80, the Court of Justice held the improvement within the meaning of the first condition must show appreciable objective advantages of such a character as to compensate for the disadvantages. Now, the words appreciable objective advantage of such a character to compensate, we will see repeated a few times when we get to the CJEU's judgment. But you apply what the Commission is saying in paragraph 85 and footnote 80 is that essentially, we see when we come to the Commission decision, merchants must be compensated.
I mean, footnote 80 again is talking about the first condition
It
of
is.
Article 81.3. I'm just very slightly confused why in a section of the guidelines headed second condition of Article 81.3, they're footnoting something that's dealing with the first. Can you help with that?
Yes, well, maybe I can answer that by going to the next footnote, which is that, and then if I don't answer it, then I'll come back to it. If such consumers are worse off following the agreement, the second condition of Article 81.3 is not fulfilled. The positive effects of an agreement must be balanced against and compensate for its negative effects on consumers. Now that is footnote 81. So we'll come, and that, footnote 81, refers to, it is recalled that positive and negative effects on consumers are in principle balanced within each relevant market. See paragraph 43. Now this is the paragraph 43 that Mr. Justice Phillips unfortunately forgot. So we need then to go to paragraph 43, which is at 1622, because this is where we are starting to look at two-sided markets. Are benefits in one market of such a character to compensate for the harm in another market? So paragraph 43 is extremely important, because we shall see that it gets applied up the chain. If I can read paragraph 43, the assessment under Article 101.3 of benefits flowing from a restrictive agreement is in principle made within the confines of each relevant market to which the agreement relates. The community competition rules have as their object the protection of competition on the market and cannot be detached from this objective. Moreover, the condition that consumers must receive a fair share of the benefits implies in general that efficiencies generated by the restrictive agreement within a relevant market must be sufficient to outweigh the anti-competitive effects produced by the agreement within the same relevant market. So you've got to look at the same relevant market. Negative effects on consumers in one geographic market or product cannot normally be balanced against and compensated by positive effects for consumers in another unrelated geographic market or product market. So at the moment, you can't balance off benefits to cardholders to merchants. However, and this is critical, however, where two markets are related, efficiencies achieved on separate markets can be taken into account, provided that the group of consumers affected by the restriction and benefiting from the efficiency gains are substantially the same. And it is very important to underline the words, provided that the group of consumers affected by the restriction and benefiting from the efficiency gains are substantially the same. So you can have two related markets. One benefit can be offset the other, where they're related, but provided the consumers are substantially the same. And the case of the Maritime case in 57 showed they were the same. They were users of transport services, but in different markets, sea and road. So that is paragraph 43. And we summarize the position at 183, paragraph 183 of our written case. That is at MS 5065. So I say we tried to set out as much as possible in our written case. We set out the guidelines, and the position, this is paragraph 103 at MS 5065. So it's core bundle 1, 5065, the position has therefore been clear for a very long time that under the fair share condition and the first condition, it is generally impermissible to balance adverse effects on consumers in one market against benefits to consumers on an unrelated market. Where the markets are related, so for example in our case, it is permissible to take account of positive effects on one market and weigh those against negative effects on another market, but only where the consumers affected by the restriction are the same consumers as those benefiting from the restriction. That is why, ultimately, the analysis stays in the acquiring market with merchants, because everybody accepts that merchants and cardholders are not substantially the same consumer. Can I then...
So going back to the question that Lord Sales raised a moment ago, the Commission's way of analysing this, if I'm following your argument, is to say that the first condition requires that economic benefits be established. And the question of balancing arises at the stage of a second condition. And that's where you're balancing effectively the harm suffered by consumers as against the benefits received by the same group of consumers.
Yes.
And deciding whether the benefits compensate for the harm.
Yes. Yeah. With one caveat, which is, well, the answer is yes. But under the first condition, it's got the benefits have got to be of the right character to compensate the affected consumer in the first place. Because if they're not of the right character, then you don't even start the balancing exercise.
Yeah. And insofar as we see judicial dicta in some of these cases, which indicate that balancing is done at the stage of a first condition, that's simply a different way of analysing it.
Yes.
Well,
I mean, clearly you are balancing in the first condition because you've got to have an improvement. But it's when it gets to the second condition that you are really balancing off the benefits by reference to the harm.
Yeah, I mean, the whole idea of balancing requires you to identify who you're talking about, because you have to have the harm suffered by an identifiable group and the benefits received by an identifiable group. And if they're the same group of people, then you're evidently into the fair share part of 813.
But there is a real key balancing exercise in the second condition.
Yes.
It's not to say that you're not, when you're looking at improvement in distribution, you're not looking at the overall alleged efficiencies. But you are certainly balancing in the second condition because you're trying to work out whether that group of consumers is actually harmed or no worse.
In the first stage, you might promote technical and economic progress without giving consumers themselves a significant benefit. Well, the second stage is the additional requirement of them getting a share of that benefit. So the balance really comes in condition 2.
It does. Not to say it doesn't come in at 1 because you are looking at improvement, but it really comes in at the second stage where you've identified your group of consumers that have been harmed. They're paying a fixed price, and now you're trying to work out whether they're going to be compensated in full.
But I mean, society as a whole might benefit under condition 1 rather than the particular consumers. You may create economic growth, you may achieve other social goods under condition 1. And condition 2 then narrows down and says, well, out of this benefit, what are the relevant consumers getting?
That's
yes.
I mean, I follow that logic, but I'm still slightly mystified by the way in which both the Commission deal with it in the guidelines by referring to an authority on the first condition as relevant to what my lords have identified as the second question. And I think when we come on to the CJU's judgment in MasterCard on this, which I spent some time trying to puzzle over, one gets a similar tension, if that's the right word, that you'll come on to it, I know, it's sort of paragraphs 240 and following, where they're talking first about the first condition, and it seems within their discussion of that, they're bringing in these elements about fair allocation of the benefits.
That is
Anyway,
what-
when you come to that, I would be grateful for some assistance on that.
Of course. But that is why, if we go back to footnote 80, I asked the court to just underline for the present purposes, must show appreciable objective advantages of such a character as to compensate for the disadvantages which they cause. Because essentially what the CJU did in MasterCard was to say, actually, cardholder benefits in themselves are not of such a character as to compensate. And therefore, because the schemes were arguing in MasterCard, well, we recognise that merchants don't get any benefit, but cardholders do.
Right, but I mean, this notion of compensation, it slightly depends upon what the detriment is and what you are prepared to count as compensating. So as my lords were saying, if one has a rigid divide, or fairly rigid divide between the first condition and the second condition, you could ask in quite general terms of the first condition, well, society suffers a detriment to the extent that there's a restriction of competition, but does society, looked at generally, derive gains
Yes.
in some way, shape or form,
And
looking at society,
Yes.
as opposed to just looking at the consumers in the particular market.
And there is no doubt that under the first condition, you can look at, efficiencies, improvements. It's far wider. It's only when you get to the second condition that you've actually got to take a rain check and make sure that the affected people are no worse off.
Yeah, I follow that logic. I think what I'm asking for in due course is some assistance, in particular when we get to the CJU's decision in MasterCard, as to how the CJU reasons that through. Thank you.
You're approaching it on the footing that when in footnote 80 they speak of compensating for the disadvantages, well, compensate whom?
Yeah.
Compensate the consumers who have suffered the disadvantages for those disadvantages.
And we see that loud and clear from 85 and 86. The person who has got to be compensated in full, this is paragraph 86, is the person who has been harmed by the restriction of competition. It is market specific.
Yes, those who suffer from the higher prices are to be compensated.
In full, yes. And if there are other efficiency gains, social benefits, so be it. So those are the guidelines. Could I just then quickly go to, I think we can put those away now, but paragraph 43 and substantially the same consumer is important. Could we go, please, to Appendix 1D, how the Commission dealt with it. And that is at MS 7093. of the decision, section 8.3, second condition, fair share of benefit to consumers. So, 7093, paragraph 734. Again, we see the Commission essentially applying its own guidelines there. You see the reference to paragraph 86. And then all I want to do is then go over the page to paragraph 741 at MS 1795. I think we've seen this before. this is how the Commission analyses the MIF. 4 or 5 lines down, MasterCard's issuing banks are also not obliged under the network rules to use interchange proceeds from MasterCard's MIF in a particular manner, and it remained unclear to which extent MasterCard's issuers indeed passed on the fee proceeds onto their customers. So that's to one side. However, it can be left open in this case whether cardholders sufficiently benefit from MasterCard's MIF. The Commission's concern under the second condition of Article 81.3 in this decision relate to the customer group which bears the costs of the MIF, that is, the merchants. That is applying standard practice to the specific case at hand, the MIF, but it is of general application. The guidelines are obviously general, and this is the guidelines are being applied specifically to the MIF. The merchants are the category of consumer which is harmed. The MasterCard obviously appealed that. I don't think we need to go to core volume. We go to the General Court, which is obviously at Primary Authorities 2. The relevant paragraph, I'm going to take the General Court quickly because I want to go to the Advocate General. If we go to MS 964, at paragraph 228, we see essentially the General Court rejecting MasterCard's appeal. The emphasis is on merchants. The last 2 lines of paragraph 228 necessarily means that the existence of appreciable objective advantages attributable to the MIF must also be established in regard to them, that is the merchants. So the Commission has said merchants cannot be any worse off. MasterCard has appealed and the appeal is dismissed. What I would like to do is go to the Advocate General, because there one sees a more discursive examination of this issue.
Yes, we see the start of 228, a recognition that condition 1 may apply much more generally than the relevant
Absolutely.
market.
Yes.
Which is the point we were making.
Yeah, and I mean, everyone accepts that, my lord.
Yeah.
So Advocate General Mendozzi is at tab 25, and we can pick it up at paragraph 153, which is at MS 1035. 1035. And it's essentially paragraphs, so 1035, essentially paragraphs 153 to 160, which are the relevant paragraphs. So by this time, and it's important to see how the MasterCard and the banks are arguing it, they recognise that they haven't proved any specific advantages for merchants, but they're saying cardholder benefits can benefit the merchants. And the Advocate General defines the point of law at 154. The point of law underlying that complaint is therefore whether, in order for the exemption provided under Article 1013 to be applicable in such a context, it is necessary that the fair share of the profit resulting from the advantages arising from the agreement, as provided for in 1013, be reserved for the direct consumers of the services provided on the market on which the restrictive effects for competition are produced, in this case in particular merchants, or whether it can be considered that the restrictive effects harming those consumers may be compensated by the advantages produced for consumers of the services provided on a related market, namely in this case, cardholders. So the point of law is being absolutely squarely posed. 155 emphasises fair share. 156, I emphasise the words in the middle that, again, we pick of Constant and Grundig. The appreciable objective advantages created by that must be of such a character as to compensate for the disadvantage which they cause for competition. The Advocate General also goes on to say that the consumers must be compensated in full. That's 1, 2, 3, 4 lines up. Must be compensated in full. This is relevant to Visa's marginal benefit argument that we'll come on to in a moment. To my mind, that compensation must apply to consumers who are directly or indirectly affected by the agreement. This is paragraph 157. It is the consumers that suffer the harm caused by the restrictive effects of the agreement at issue that must, in principle, be allowed as compensation for that harm, the fair share of the benefit resulting from the agreement referred to in 101.3. In fact, if it were possible to take into consideration the advantages resulting from agreement for one category of consumer of certain services in order to counterbalance the negative effects on another category of consumer of other services on a different market, that would amount to allowing the former category of consumers to be favoured to the detriment of the latter category. The Advocate General at 159.160 then is quite important. I must further observe that those considerations are not inconsistent with the settled case law of the General Court referred to at 228, according to which it is not excluded that it may be possible to take into consideration the advantages resulting from the agreement that can occur on a different market from that on which the agreement produces for the restrictive effects. Such advantages may be taken into consideration where, for example, the category of consumers affected by the agreement on the two separate markets is the same. So the Advocate General is expressly endorsing paragraph 43 of the guidelines. Yes, you can take into consideration benefits in a related separate market. When you're weighing, but they've got to be, the consumers have got to be, the Advocate General says the same, the guidelines say substantially the same. In the present case, the General Court considered that in order for the exemption to be applicable, it is necessary that the existence of appreciable objective advantages arising from the MIF is in any event proved for merchants. Insofar as merchants constitute the category of consumer that directly suffer the restrictive effects of the MIF on the market on which those effects are produced, I consider that the General Court did not err in law. In other words, the point of law was which market is relevant. That's at 154. And the conclusion is it is the market affected by the agreement. It is accepted that cardholders and merchants are not substantially the same consumer, and therefore cardholder benefits are not of such a character to compensate for the harm suffered by merchants. That is the sense in which my submission, when we get to the CJ judgment, which we'll turn to now. So that, if we can go first of all to paragraph 234 at 1079, so where we're heading now is whether, on Visa's interpretation, the previous case law has been swept away. That's essentially the point. So paragraph 234, the CJEU restates Constant and Grundig. The important point is the improvement must in particular display appreciable objective advantage as such a character to compensate for the disadvantage which the agreement entails for competition. So if you're You've got to work out whether the benefits are in another market are of such a character as to compensate. And then we get to paragraph 240, 241, 242 and 247, to which Miss Rose referred to. Can I emphasise 241 and 242? Because I think one has to read it logically. It follows from this that, and then should the General Court have found that there were appreciable objective advantages flowing from the MIF for merchants, even if those advantages did not in themselves prove sufficient to compensate for the restrictive effects identified pursuant to 1011, all the advantages on both consumer markets in the MasterCard scheme, including therefore on cardholders' market, could, if necessary, have justified the MIF, and then emphasise, if taken together, those advantages were of such a character as to compensate for the restrictive effects of those fees. If. And then 242 is important. We start with however. However, as is recalled in 234, the present judgment, Constant and Grundig, examination of the first condition laid down in Article 1013 raises the question whether the advantages derived from the measure at issue are of such a character as to compensate for the disadvantages resulting therefrom. Thus, whereas in the present case restricted effects have been found only on one market of a two-sided system, the advantages flowing from the restrictive measure on a separate but connected market also associated with a system cannot in themselves be of such a character as to compensate for the disadvantages resulting from that measure in the absence of any proof of the existence of appreciable objective advantages attributable to that measure. And then this is the last two lines are the lines that Miss Rose did not read out, in particular, as is apparent from 21.168, where the consumers on those markets are not substantially the same. So when Ms. Rose took the court to paragraph 242, no one read out where the consumers on those markets are not substantially the same.
And I think what I was finding a bit confusing about that is that seems to be in the context of a discussion of the first condition.
Yes, because
Why?
basically what it's saying is that you don't get past first base, even under the first condition, if you've got a group of consumers that is harmed. You're saying there are benefits out there, but you've got to work out that those benefits are of such a character as to compensate for those consumers in the first place.
Right, but that makes it sound as though it's the first condition doing the work of ensuring that the particular group of consumers in the particular market are compensated fully for the disadvantages that they suffer. Whereas I understood before you were saying that work was being done by the second condition. Well,
it is. I think 247, one sees that it relates to the second condition. But all I'm saying is that certainly that's the second condition, because we saw that in the paragraphs. All that the court is saying here is that are the benefits that you allege are of such a character as to compensate. If they're not, then you don't even look to see whether there's an improvement. You don't even get to the second condition. Because the argument, it's important that this is in the light of the arguments put by the schemes. The scheme was saying, we recognise there are no merchant benefits. We haven't proved merchant benefits, but you can take into consideration cardholder benefits. And the court is saying, well, you can take into account cardholder benefits, but they've got to be of the right character. And they're not of the right character because the consumers are not substantially the same. Can I then just go to how Visa interprets the CJE ruling and then deal with the Court of Appeal? and then I'll be moving on to broad acts. So we have the, we'll come back to this when we get to the Court of Appeal, but can I articulate how Visa interprets the CJEU ruling? And basically, it advances a marginal benefit analysis. So the argument appears to be as follows. Visa accepts that the acquiring market is distorted because a price-fixing agreement raises prices in the acquiring market. So it accepts that the acquiring market is distorted. It accepts that the issuing market is separate. Visa accepts that merchants and cardholders are not substantially the same. This is important. It contends that consumers in the distorted acquiring market must receive some benefit. Not full compensation, some benefit. This is their marginal benefit analysis. Therefore, the consumers in the separate issuing market can be benefited at the expense of the merchants in the acquiring market. And importantly, the logic of this marginal benefit analysis appears to be as follows. Cardholder benefits are not of such a character to compensate merchants if merchants do not receive any benefit. So I'll repeat that. Cardholder benefits are not of such a character to compensate merchants if merchants do not receive any benefit. However, cardholder benefits are of such a character to benefit merchants if merchants receive a marginal benefit. Cardholder benefits have, therefore, a chameleon-type quality which is not dependent on whether or not the consumers are substantially the same. They're not of the right character if merchants get no benefit, but they become the right character if you can prove that merchants get some benefit. But could I go to the Court of Appeal?
But before we leave this, it rather looks as though the court is adopting a different analysis from the General Court, and it's prepared to accept that where you have a two-sided system with related markets between which there is interaction, then in principle you can take account of benefits in the related market, but only in a situation where there are benefits to the consumers in the market primarily affected. Or I got that wrong?
You can take account of cardholder benefits. There's no doubt about that.
Yeah, and that's because of the interaction between these two related markets.
Yeah, you could, even if it wasn't related, if it was just if it was a general efficiency. But
Well, at what stage of the analysis? You're talking about the first condition.
Whether the benefits in the cardholder market are of such a character, in circumstances where you've proved no benefit to the harmed consumer, are the other benefits are of such a character as to in principle compensate?
Yeah,
because if they're not in principle liable to compensate, you'd not even pass first base.
Yes. That's what the court is saying.
Yes.
For here, even if the General Court adopted the wrong analysis, it doesn't matter because there was no evidence of benefits to the merchants. Therefore, that's an end of the fair share issue.
I think, to be fair to the General Court, when one sees there's lots of arguments being run in this case. When you got to the General Court, MasterCard was still arguing that there were benefits to merchants. When it got to the CJEU, they recognised that that was gone. There were no benefits to merchants, and therefore they rested their case on the argument, even if there are no benefits to merchants, we can still win because there are many, many cardholder benefits. So I think, to be fair to the, and maybe Mr. Khan will articulate this, I think that things slightly moved on from the General Court to the CJU. So if I go to the Court of Appeal, which we know is at Bundle 2, tab 23, see, Core Bundle 2. It starts at page 38, MS 5228. I haven't got time to go through this in detail, but it is the relevant paragraphs are paragraphs 91, essentially to 104. So this is the Court of Appeal's analysis of the second condition, paragraph 91 to 104. And what I'd like to do is pull together the Court of Appeal's reasoning and say that we endorse the Court of Appeal and we submit that Visa's interpretation is wrong for at least 3 reasons. Now, the first reason is that the Court of Appeal was correct in its 5th proposition, which starts at paragraph 91, MS 5228. So, at paragraph 91 and 92, the Court of Appeal refers to paragraph 43 of the guidelines, paragraph 242 of the judgment, and essentially we say that the court is endorsing paragraph 43 of the Commission's guidelines, endorsed by the Advocate General's opinion at paragraph 156, and the Court of Appeal was correct in its 5th principle. In a nutshell, if you are going to take consumer cardholder benefits into account for the purposes of whether they compensate merchants, they've got to be of the right character and the consumers have got to be substantially the same. And that's why at paragraph 91, it's important, the last 2 lines, unless the group of consumers in each market is substantially the same, which is not the case here. Again, the Visa's argument is that essentially this is the CJU departed from established practice, and we pray in aid paragraph 104 because the Court of Appeal is saying we consider therefore that nothing in the judgment of the European courts in MasterCard alters the established position. So that's paragraph 104. And we say that if the CJU had indeed wanted to alter the established position, as in paragraph 104, one would have expected something more radical. Because as I say, these guidelines have been in force for many years. They've been applied expressly to the MIF, and one would not expect the CJU just sub silentio to alter the established position. So that's the first reason. We say the Court of Appeal was correct in its 5th proposition. The second reason is that Visa's marginal benefit interpretation does not give proper consideration to the notion of compensation. And we respectively endorse what the Court of Appeal said at paragraph 102 of the judgment, MS 5230, where the Court of Appeal said there are not appreciable objective advantages to the merchants in the acquiring market unless the advantages caused to them by the myth outweigh the disadvantages. Only then can it be said that they have received a fair share of the benefits. That is the sensible interpretation of both the General Court's decision and the CJU's decision, and it accords with what's stated in paragraph 43 of the guidelines. In other words, if I take £100 from Visa, and give Visa £10 back, it can hardly be said that Visa has obtained an appreciable advantage to compensate for its loss. It's £90 down, whatever way one cares to look at it. And I remind the Court that in this respect about compensation, the guidelines paragraph 86 and the Advocate General paragraph 156 refers to full compensation, fully compensated, not marginally compensated. That's the second reason. The third reason we don't get from the Court of Appeal, but it is this. In my submission, the marginal benefit interpretation does not accord with the objective of Article 101, which is to ensure markets are not distorted. It's not within the spirit of Article 101, as Constantine Grundig said. If consumers pay high prices in the distorted market at the expense of others, that market remains distorted. And on this point, Visa's subtext is important here. And this is because, in reality, issuing banks are extracting money from merchants to subsidize competition amongst themselves. By the price-fixing agreement, they extract a fee that can be increased at will. That is the nature of the myth. They say they use the money to benefit cardholders. But that means that the issuing banks are giving money to cardholders to attract custom. They want to be more attractive to cardholders. Whether the money actually goes to cardholders or simply increases the bank's profits, we know is another matter. But assuming that the money does go to the cardholders, merchants are simply subsidizing competition in another market. And that, in our respectful submission, is not a sensible application of competition policy. To have a price-fixing agreement to subsidize competition. That is all I would like to say, unless my Lord has any questions on fair share. I was going to move to pass on the broad acts. I think we'll need call bundle 2, because we'll go to the Court of Appeal judgment. But can I just, by way of introduction, make some opening remarks? So this is the fourth issue, which is MasterCard's appeal on pass-on and broad acts. Things seem to have moved on so far as Sainsbury's is concerned, because MasterCard have put forward a test, but have accepted that MasterCard will not satisfy its own test so far as the Sainsbury's claim is concerned. So, on one view at least, it means that, well, it certainly means that the tribunal's judgment on pass-on remains intact, because MasterCard in oral submissions have accepted that it does not even meet its new broad acts test, because it can't show any identifiable link between the overcharge and higher downstream prices. It would logically follow that the appeal by MasterCard would be dismissed, but what we are being asked to do is to make some submissions on MasterCard's test insofar as it would apply to AAM and in the Visa case. But so far as the tribunal's judgment is concerned, in the light of Mr. Hoskins' oral submissions, that must remain intact. So I will concentrate, I will now limit my submissions, because obviously I had something to say about the MasterCard Sainsbury's appeal, but I will limit my submissions more generally. If I can start by summarising MasterCard's case on broad acts. I think we know what it is, but I think it's important to get it down. First, MasterCard accepts that the merchant has been subjected to an unlawful overcharge. The MIF unlawfully inflates the merchant's cost base, and the merchant is therefore entitled to claim damages. The damages are calculated by reference to the actual price paid and to the price that would have been paid in the counterfactual. So MasterCard accepts there's been an unlawful overcharge, accepts claim to damages, and the damages are calculated by reference to the actual price paid and the counterfactual price. Second, MasterCard alleges that the overcharge, in fact, did not cause the merchant loss, because the merchant passed on the overcharge in the form of higher prices. So no loss because it passed on the overcharge in the form of higher prices to its own customers. In this respect, MasterCard accepts that it must prove a sufficiently direct causal link between the upstream overcharge and the downstream higher prices. We'll come on to this, but MasterCard accepts that it must prove a sufficiently direct causal link between the upstream overcharge and the downstream higher prices. Third, and this is where we get to MasterCard's new test, MasterCard submits that once it has shown that the overcharge caused some increase in downstream prices, the actual amount of pass-on can be estimated by the broad acts. So once it's shown that the overcharge has caused some increase in downstream price, the actual amount of the overcharge can be estimated, the actual amount of the pass-on can be estimated by the broad acts. So as I understand it, if the overcharge is £100 and it can prove that £10 has been passed on in the form of higher prices, MasterCard can now estimate a further percentage of pass-on. The implication of this must be that MasterCard has proved that, say, £10 was in fact passed on because there's a sufficiently direct causal link, but it cannot prove a sufficiently direct causal link for the rest. That's why it wants to estimate. In our submission, that approach is misconceived, and that is because this broad acts approach to the rest is inconsistent with EU and domestic principles on causation. It confuses broad acts with EU principles and domestic principles on causation. And causation principles are the principles which apply in the case of the pass-on defence. Could I'll do this primarily by the Court of Appeal. I need to go to a few cases. The Court of Appeal's judgment, as we know, is at Core Bundle 2, at MS 5273.
Sorry, just before we get there,
Yes, sir.
you said inconsistent with EU and domestic principles. Which should we be concerned with?
I'll come to that, but there's an EU principle that the pass-on defence must be interpreted strictly. There is an EU principle which says you must show a sufficiently direct causal link.
But why aren't matters of causation a matter for national law?
Well, they are, but under EU law, the pass-on is subject to EU conditions, as we'll see in a moment. And EU law requires a direct link between the overcharge and the higher downstream prices. That is what EU law requires. MasterCard accepts that, and is also, the EU condition is also consistent with Fulton Shipping, the Supreme Court, and our domestic principles on causation.
So are you saying that we have to apply both EU principles and national principles?
Yes, well, what I'm saying is primarily because we're still under EU law, the pass-on defence is subject to EU principles. The EU principle that there is a direct causal link, which MasterCard accepts, is also consistent with our domestic law principles.
But it sounds from the way you're putting it that doesn't matter. If there was a conflict between them, you seem to be saying that it's EU principles that apply.
Well, EU principles are the overriding conditions for the reasons I'll articulate in a moment. It so happens that one of the conditions, the direct causal link, is also consistent with how the Supreme Court interpreted causation and benefit in Fulton Shipping, and MasterCard indeed accept that it must prove a sufficiently direct causal link.
I think what I'm asking for is whether you have a submission that it is EU law which governs the question of causation in relation to the passing on.
It undoubtedly does.
Right.
It undoubtedly does.
So, and if that's so, why do we worry about national law, do you say?
Well, we don't. But
So that drops out the picture on your submission?
It does drop out the picture,
Right.
although MasterCard accept that the EU law principle is consistent with domestic law, which is not an irrelevant consideration. It helps if EU law is consistent with domestic law on this issue. But where the EU law are not aware of a domestic law principle which says that the pass-on defence must be interpreted strictly, but there is an EU condition to that effect.
Thank you.
There seems to be a danger of ships passing in the night, because as I understand MasterCard's submission is we're not talking about causation at all. We are purely talking about quantification. And you say, no, this is causation. And it seems that the issue is that there has been proved some degree of pass-on, but it's difficult to ascertain how much. You say that's causation. MasterCard say it's quantification. Is there any authority to vouch one or other categorization?
Well, I mean, I will go through the logic of why the EU law principle applies, but where I end up is endorsing what the Court of Appeal said, and maybe we can just go to that now, because that kind of, if one goes to MS 5275, it's paragraph 331 and 332. And it's not the whole of paragraph 331, it is only halfway down where we get to fourthly.
Yes.
So there are two paragraphs. So fourthly, we do not accept Mr. Hoskin's submission that the broad act principle of establishing recoverable loss, which we have discussed in the context of the first one, applies to the burden on MasterCard to establish the fact an amount of pass on by Sainsbury's. The Broad Acts principle is applicable when the claimant has suffered loss as a result of the defendant's culpable conduct, but there is a lack of evidence as to the amount of such loss. There is no scope for the application of any such principle where the burden lies on the defendant to establish a pass-on of the unlawful overcharge in order to reduce the amount recoverable by the claimant. We say, and I'll come on to this, pass-on is a question of causation. It's not, you've got to prove that the overcharge led to higher prices. Now, again, we will come on to this, but quantification sometimes is a different exercise, because often one is looking at a counterfactual. Here we're looking at an historical fact. Was the overcharge in fact passed on? And there is a paragraph in the one-step case, and that's paragraph 37, which deals with the counterfactual in a quantum exercise, because sometimes it is difficult to be precise. In pass-on, it is an historical fact. We don't disagree with paragraph 332 of the judgment. On the other hand, we accept Mr. Hoskins' submission that in each case it is a matter for the judge to decide whether, on the evidence before her or him, the defendant can show that there is a sufficiently close causal connection between an overcharge and an increase in the direct purchaser's price. We see no reason why that increase should not be established by a combination of empirical fact and economic opinion evidence. It is not appropriate for us on these appeals to be more specific as to the nature and type of evidence capable of satisfying a trial judge that there is a sufficiently close causal connection. So we say that is a standard approach to the issue of causation, and it is for MasterCard to bring evidence, as it did in the Sainsbury's case. Sainsbury's opened up its books, management accounts, budgets, its CEO was cross-examined, the CFO was cross-examined, there was expert evidence adduced by both sides on the issue of pass-on. MasterCard adduced a forensic accountant. So there was not an absence of evidence, there was an absence of proof. But paragraph 331 and 332, we say encapsulates the law on pass-on, subject to the EU conditions that I'm going to refer to. So I'm not actually sure why MasterCard want to employ a broad axe, because the broad axe is employed where it is a sound imagination. You're looking at a hypothetical counterfactual.
Sorry, but why isn't it obvious why they want to apply it?
I beg your pardon?
Why isn't it obvious why they want to apply it? It means that they will have a greater defence.
Yes. That I can.
Sorry, I was just mystified by you saying it. You couldn't see why they wanted to do it.
Well, why in law? Clearly, they want an easier. They want to be able to estimate pass on. But as a matter of law, it's not clear why they want to employ a broad axe. They're entitled to adduce evidence. It's not. All I'm saying is it's not like in proving a fact that never existed, which is often the case in quantum, where you've got to look at the actual and then what would have happened. You can't have direct evidence of a fact that never happened. That's why you have to employ a sound imagination and use the broad axe. But in the case of a fact that actually happened or did not happen, historical fact, they just need to leave the evidence in question. There's not the same legal difficulty in proving the historical fact as opposed to a fact that never happened in a counterfactual. That's all I was trying to.
Thank you.
Can I then just go to the Court of Appeal's judgment, because it is important to see why EU law principles do apply. And Mr. Hoskins said, I got the impression he was going to come back maybe in reply on the EU principles, but the starting point is at paragraph 323. The starting point is that persons harmed by breach of EU competition law have a right to compensation in the domestic courts of EU member states under domestic laws and rules which comply with EU principles of equivalence. So we'll see the Courage and Crean case in a moment. But as a matter of interpretation of Article 101, if someone is harmed by an anti-competitive agreement, they have a right to claim damages. But then we get the words, but such domestic laws and rules may prevent unjust enrichment from overcompensation. That's Courage and Crean. Where an unlawful charge has been borne not by the direct purchaser but the customer of that purchaser to whom the cost has been passed on, repayment of the full amount of the unlawful charge to the direct purchaser would amount to paying the direct purchaser twice over, and it is for the domestic courts to decide whether that would be, in all the circumstances, amount to unjust enrichment. Could we just quickly go to the Courage and Crean case, because it does actually set this out. That's at volume 9, tab 71. Volume 9, 71, at 3646, 3646. So the court will be familiar with Courage and Crean, the beer tie case. Mr. Crean suing Courage for lost suffered. This is the reference from the Court of Appeal, and so it's MS 3646. And we do set this out in our written case. But this case established the right to compensation for breach of the competition rules. And it's paragraph 25 which establishes the right to compensation. As regards the possibility of seeking compensation for loss caused by a contract or by conduct liable to restrict or distort competition, it should be remembered from the outset, in accordance with settled case law, the national courts whose task it is to apply the provisions of community law must ensure that those rules take full effect and must protect the rights which confer on individuals. So these are the subjective rights which are conferred on individuals. 26. The full effectiveness of Article 101 of the treaty, in particular the practical effect of the prohibition laid down in Article 101, would be put at risk if it were not open to any individual to claim damages for loss caused by a contract or conduct liable to restrict competition. 27 introduces essentially a policy reason. Indeed, the existence of such a right strengthens the working of community competition rules and discourages agreements or practices which are frequently covert, which are liable to restrict or distort competition. From that point of view, actions for damages before national courts can make a significant contribution to the maintenance of effective competition in the community. So this right is, to a certain extent, based on policy, twin policy, the full effectiveness of Article 101, that's paragraph 26, and strengthening the community competition rules, paragraph 27. Paragraph 30 then is important because it acknowledges the pass-on defence, essentially. In that regard, the court has held that community law does not prevent national courts from taking steps to ensure that the protection of rights guaranteed by community law does not entail the unjust enrichment of those who enjoy them. And then we see particular the Hans Just case, and the Hans Just case is a tax case, and it is in tax that the principle of pass-on and unjust enrichment has applied, But the court is referring to the Hans-Just case as an example of that you can have pass-on in, or as an exception to, the right to claim damages.
Well, I mean, in domestic terms, there's a lot of confusion of categories going on here. I mean, in domestic terms, you have a constitutional right to the repayment of a tax that was unlawfully levied. But there may be reasons to do with unjust enrichment why the court might deny you that recovery. Well, it's a very contentious issue in law of restitution, but at least arguable that there might be reasons of unjust enrichment why that right should be denied, at least recovery in full.
Yes.
But if you're talking about damages, then damages depend on proof of loss. If you've passed on the cost that was wrongfully imposed on you, you didn't suffer the loss.
Correct. Well, and that's what the Court of Appeal said in Devonish. But it's important to realise that the CJU is referring to the Hans-Just case, which supports a pass-on type approach to whether you've suffered loss or not.
But in the English law of damages, it's not a defence of pass-on. It's simply you simply have the claimant has a burden of proving they actually suffered, what loss they actually suffered, and their evidence can be tested. And if it appears that they raised their prices in order to avoid suffering a loss, then
Well, in respect,
so be
I
it.
slightly part company on that, because the pass-on defence is a defence. If you're claiming damages, Sainsbury's has proved loss. It's shown what the actual price paid was and what the but-for price was, and therefore it has got whatever it is.
it doesn't follow that it suffered that loss.
That's not a loss. That's merely the differential between what you paid and what you should have
Yeah,
paid.
that's just
The
arithmetic.
next question, which has to be answered, is: did the creation of that differential cause you loss?
And I agree, but it is the defendant to prove that the claimant has not suffered any loss, because it is undoubtedly the case, and it is accepted by MasterCard in the present case, and one looks at paragraph 324, that is why it is important to look at the EU principles, and this is now enshrined in the Competition Act, Schedule 8A, the burden of proof of proving pass-on is on the defendant.
Well, if you're going to tell us that it's a statutory defence with a statutory rule about onus, well, so be it. In a common law, we would, I at least, would resist the idea that it's a defence, and I'd also resist the idea that there's a legal burden of proof on the defendant.
Yeah. Well, I mean, I'll find out tomorrow whether Mr. Hoskins disputes this, but if one goes to paragraph 324...
Sorry, in the present case, are we concerned with the statutory rules? Because we're going so far back. Do they apply to this claim?
First of all, it's not disputed, it's never been disputed, that the legal burden of proof of proving pass-on, that is to say, you, O claimant, have not suffered any loss, is on the defendant. And that is an EU principle, which the Court of Appeal refers to at paragraph 324. MasterCard accept that, and that principle is now enshrined in Schedule 8A to the Competition Act.
And does the Competition Act apply to this claim?
No, because no.
Right, so we can forget about that.
We can, but what I'm saying is that Parliament has endorsed what the EU principle dictates, which is that the legal burden of proof is on the defendant to prove that you passed on and therefore you suffered no loss.
Well, I can see in the cases referred to in 324 why that should be the case, because you're talking about beverages duty, unlawful dock dues, and San Giorgio was a state charge, I think.
Yes.
Yes. So these are all charges imposed by the state on an individual, and the claim is for the repayment of an unlawful charge made. Here, you, the merchants, are claiming damages from the schemes, and the question is who bears the burden of proving the loss, which seems to me a radically different question.
Well, the answer to that is it has proceeded on the basis until 2 minutes ago that the claimant proves loss in the form of the overcharge, and the overcharge is the difference between the price actually paid and the price that the claimant would have paid in the counterfactual. That is the overcharge. It is and if there is no, I mean, who raises the pass-on defence? It cannot be the case that you prove the overcharge, but then you've got to go further and show that you didn't pass it on. The allegation is made by the defendant. The defendant says, I did overcharge you. It was an unlawful charge, but you, O claimant, have not suffered any loss because you passed it on. That is an allegation raised by the defendant. He who asserts or she asserts must prove, and it's always been the case since San Giorgio in the case of passing on, and the CJU refers to the Hanjus case, and therefore the principle applies equally to pass on in competition law. The burden of proof is on the defendant.
Well, I'd like to see clear CJU authority to that effect. We may be bound by that, but certainly using a domestic analysis, I would have said your claim is a claim for damages, and the question which this court has to answer is, what is your loss? And prima facie, the burden would be on you to show that you'd suffered loss.
Well, and that's what the claimant does by proving the overcharge. The difference between what MIF should have, that's the MIF, but it can't possibly be, with respect, it can't possibly be the case that a claim, and the reason that the CJU said the burden was on the defendant is because it's very difficult for a claimant to prove a negative. That was the rationale in San Giorgio. And
so does it go back to something to do with the principle of effectiveness?
and that's indeed why the Court of Justice in San Giorgio said that the burden of proof must be on the defendant, because otherwise it would be contrary to the principle of effectiveness in EU law, and that must apply as much to competition law, the right to claim damages, as it does to an overpayment of excise duty.
But looking at it practically, the only evidence as to the existence or non-existence of pass-on will come from the merchants, not from the scheme, because the scheme creators don't know what you have done with your cost base and how far you've passed it on. This is information peculiarly within the knowledge of the retailers.
It's not within the knowledge, because the retailer doesn't necessarily know what he's passed on. But my lord is absolutely right in that in all these cases, in these cartel damages cases, there will be disclosure relating to the overcharge, and then if the defendant raises you suffered no loss because of pass-on, there will be disclosure by the claimant, as happened in the Sainsbury's case, of its management accounts, its budgets, and anything that the defendant says is relevant to pass-on. But there is always disclosure by the claimant on the issue of pass-on.
Thank you.
But that is the reason that in competition law, as well as in tax, EU principles say the burden must be on the defendant, because it would be contrary to the principle of effectiveness.
The one reason why I asked you about that is I've been puzzling about what you said about the relationship between EU law and national law. both Crehan and the Court of Appeal at paragraph 323 seem to take the position that it's national law, but subject to, that governs quantification of damages, subject to principles of equivalence and principle of effectiveness.
That's right, yes.
Right, so that's how
That's
EU law and national law mesh together, is that right?
It is. So you've got the right to claim damages, which is a principle of EU law. You then you have domestic law, which says, well, there will be a defence to that. You've suffered no loss. That's pass on. So EU law says you can have a domestic system which allows for pass on. However, it must be subject to the principles of equivalent and effectiveness. The principle of effectiveness says that the burden is on the defendant, and also, as we shall see, the CJU says that the pass-on defence must be interpreted strictly, and also that there is a direct causal link. So, although it is for domestic law to lay down principles, that is always subject to overriding EU conditions.
Well, I'm bound to say I don't think there's any guarantee we're going to endorse necessarily the approach that you're putting to us. I mean, effectively, one understands now why Mr. Hoskins is driven to the broad axe argument, because he's being asked to prove something that he can't prove. And you tell us there's a legal onus on him to prove it.
Well, he can prove it's.
Well, it's an awful lot easier for pricing decisions by a retailer to be explained by the retailer than they are by anybody else.
And in many cases, on your theory, the schemes would be driven to prove it only by inference from documents. They're not going to be able to call the witnesses from the retailers, the merchants, which are the opposing party. You've said they have disclosure, but that may be bitty. It may not give the whole picture. One's familiar with disclosure, not setting out everything in absolute detail. So why isn't a reasonable principle of inference from the disclosure, which may be all that the schemes have available on this point, not legitimate?
It happens. I mean, the asymmetry of information is the same when it comes to proving an overcharge and the but-for price. The information on the but-for price is very often with the cartellist, the wrongdoer. The claimant doesn't have that.
Right, but isn't the claimant entitled to use what we're referring to here as the broad axe principle in that situation?
It does, yes.
So when the defendant is faced with the same problem, why can't it refer to the same principle?
Well, there's two points here. The first is Mr. Hoskins' broad axe, but the second is the burden of proof. And all I'd say on the burden of proof is that the EU conditions which apply to this case and have been accepted by MasterCard, the burden of proof is on the defendant, and the burden of proof is now enshrined in the Competition Act. So if this court was to say, well, the burden is on the claimant, going forward, that would be contrary to how Parliament has at least tackled the burden of proof issue in the Competition Act.
Well, it wouldn't be inconsistent with the statute because this isn't a statutory claim.
No, but the EU principles apply. I mean, come the 1st of February, EU principles may not apply, but EU principles certainly do apply to this claim.
And you say the Competition Act is an acknowledgement of an EU principle.
It is, yes.
And applying it domestically.
Correct.
Yes. Which was the section, could you remind me?
It's Schedule 8A to the Competition Act. I can't remember which part, but
Yes.
I can give you.
Well, I'm acutely aware we've raised something that isn't part of your programme, but I would certainly welcome tomorrow some clear authority which demonstrates that in the field of competition law, that there is binding authority that the burden is on the defendant to establish passing on.
in the context of a claim under 101 or its predecessors.
Well, we will do our best. I'm not sure we're going to get any Supreme Court
No,
authority, but
no, not
certainly
at all.
we
No,
have-
it sounds as though it's the EU
it's
authority
EU
that may be
authority.
relevant.
This is an EU principle you're invoking, which, in fairness to you, has been a matter of agreement till now.
Yes, and it may be right,
Yes.
but we'd like to be given chapter and verse.
Yeah, exactly.
And then given the six, so 324, so that is a scheme of the pass-on defence, as far as my submission is concerned at least, which is that you have a principle of compensation under Article 101, that's paragraph 323. Domestic law may allow for the pass-on defence, but it is subject to overriding EU conditions. That is essentially what the Court of Appeal is saying at paragraph 323, and as we understand, MasterCard accept. 324, whether or not the unlawful charge has been passed on is a question of fact. The burden of proving lies on the defendant. We understand that MasterCard accept that, and I think that's in its written case. 325 is another EU condition which we understand MasterCard accept. It certainly referred to these cases in its submissions to the Court of Appeal. Damages would reimburse the full amount of an unlawful charge if there's been a direct passing on of the charge by the claimant to it. So there's got to be a direct passing on. That is a condition of EU law. And we say is, whether it is relevant or not, but certainly MasterCard accept it, that principle of direct passing on of the charge is consistent with domestic law. See the Fulton shipping case, which is referred to by the Court of Appeal at paragraph 330. Can I finish before 4 o'clock, just to go to one EU principle which is not referred to in the judgment, but I would ask this court to bear in mind. The Court of Appeal refers to the relevant case, that is Weber's wine, so it refers to it at 324. That is at volume 10 at tab 86. Volume 10 at 86. And everyone has proceeded on the basis that these cases apply to the principle of compensation under 101. That's tab 86, Weber's wine, and it's MS 4304.
MS, sorry.
Paragraph 93 at MS 4304.
04. Thank you.
So this is under a heading, the relationship between the passing on of the duty on alcoholic beverages and unjust enrichment. The court has consistently held that individuals are entitled to obtain repayment or charges levied in a member state in breach of community provisions. That right is a consequence and complement of the rights conferred on individuals by community provisions. Member states in question is therefore, in principle, to repay charges levied in breach of community law. Pausing there, Courage and Crean says exactly the same thing about compensation under Article 101. It then refers to the exception to make repayment. The member state may resist repayment to the trader of a charge levied, though not only where it is established by the national authorities. It follows that if the burden of the charge has been passed on only in part, the national authorities are required to repay the amount not passed on. So the court is clearly indicating there that you can have full pass on or part pass on. And 95, as that exception is a restriction on a subjective right, that is exactly what how the Court of Justice described the right to compensation. It's a subjective right derived from the community legal order. It must be interpreted strictly taking into account particularly the fact that passing on of a charge does not necessarily neutralise the economic effects. The court in particular that even though indirect tax are designed in national law to be passed on, it cannot generally be assumed that the charge is actually passed on. The actual passing on of such taxes, either in whole or in part, depends on various factors in each commercial transaction. Consequently, the question is a question of fact to be determined by the National Court. And we say that principle applies equally to the principle of compensation under Article 101. The same logic applies. I think that bombshell will...
Yes, enough excitement for one day. We'll adjourn and sit again at 10:30 tomorrow.